Hello, my name is Ioana Pantis. I'm a lawyer at Williams HR Law. The frequently asked question I'll be answering in this video is, when and how should employers issue records of employment in relation to COVID-19? Employers are generally required to issue a record of employment within 5 calendar days of an employee experiencing an interruption in earnings. This rule remains intact when the interruption in earnings is in relation to COVID-19. An interruption in earnings occurs when an employee has had or is anticipated to have 7 consecutive calendar days with no income, or where the employee's income falls below 60% of their regular weekly earnings due to a leave of absence. To meet their legal obligations, employers have to be honest as to the reason for issuing the ROE. There are various COVID-19 related reasons for employees to stop working, and there are different codes that must be used when completing an ROE depending on the reason. When an employer lays an employee off work, Code A should be used indicating a shortage of work. Where employers have been approved under the Federal Work Sharing Program, the ROE should be coded H. If an employee becomes sick due to COVID-19 or is providing care to a critically ill person, Code D should be used for illness or injury. If an employee is temporarily off work for other reasons related to COVID-19, such as to care for children whose schools are closed, or because of concerns about how contracting COVID-19 may impact their own or family member's health condition, employers should generally use Code N to indicate a leave of absence. If an employee refuses to work because of COVID-19 related fears, employers should take care to understand the basis of those fears. In many cases, even when an employer disagrees that the employee can't work in the circumstances, Code N will still be appropriate. In certain cases, other codes, such as Code E for quit, can be used, but employers should be cautious when considering these other codes as they can impact employees' eligibility for federal benefits such as regular EI benefits and the Canada Emergency Response Benefit. To streamline the adjudication process for federal benefits, the government is asking employers to avoid using the comment box to provide additional information related to the reason for issuing the ROE. Nonetheless, the comment box still exists on the ROE form, and some more unique or complex circumstances may warrant providing more information. Overall, employers should treat each case individually and request further information from employees when needed to ensure accuracy when completing ROEs. Hope you found this video helpful along with the other resources on this site. Keep well and safe.